Well, good afternoon, everyone. Thank you and good morning out in California. We're going to talk today about the executive orders and some of the activity. This presentation is designed to discuss Department of Defense related actions and activity. Quick biographical overview of me. I am Sean Timmons. I'm the managing partner of Tully Rinckey PLLC's Houston, Texas area of operations. I also cover the state of Texas and USERRA matters, which is the Uniform Services Employment Reemployment Rights Act, some Title VII claims and private employment, and a global court-martial defense practice. So I travel literally anywhere someone is assigned if I'm retained to defend those in uniform or charged with crimes in the military justice system. Ancillary to that, I handle administrative separation boards for those who are facing removal from the armed forces, and I handle all sorts of administrative military legal work. So if you have friends or family in the military and in need of legal help, I'm there for them and happy to go anywhere in the world they may be stationed. Same thing with the USERRA case. I'm practicing nationwide in federal courts from Alabama to Virginia to California. I'm admitted officially cleanly in New York, Texas, and Colorado, but I enter my appearance through local counsel or sponsored counsel in other states in what's called pro hoc vice admission. So I'm litigating USERRA claims all over the country, recently settled cases in Alaska, Oregon, and Nevada, and other states and jurisdictions throughout the nation. And that's the primary reason I live in Houston, Texas. It's a logistics hub, allows me to go anywhere in the world within 12 hours or 18 hours. So I can get to Germany just as fast as I can get to Alaska. I can get to California and to Florida about equal amounts of time. So if I was in California, it'd take longer to get to New York, and if I was in New York, it would take longer to get to California. So I'm in Texas, right in the middle. So I can go either spot quickly on behalf of those in uniform, and I can get overseas quite easily. So family stays parked in Houston. I spend about 100 days a year on the road litigating. But I'm not on the road. I'm usually here in my office in the Houston area and litigating cases locally on behalf of our firm's clients. So that's me. I have many associates who work under my supervision and direction. I want to thank all of them for their hard work and effort and contributions to our firm's success. Couldn't do the job without my assistant Maggie and all my colleagues and attorneys and partners at the firm who help throughout the process. So we can move on to the overview now slide. That's me, that's my practice. And if you want to learn more, you can look at my bio. Okay, overview. Now, today's presentation is going to cover the executive orders. It's not going to cover really outside the scope of that, meaning we're going to talk about the stuff that applies across the board to the Army, to the Navy, Marine Corps, Coast Guard, Space Force, Commissioned Corps, so the Health Service, those uniformed services. Go to slide 4 now, which we are not going to cover anything regarding military criminal justice today. Okay, the Uniform Code of Military Justice remains in full force and effect. It has not been changed to date by the president, although the president retains the authority to adjust the Uniform Code of Military Justice. I am not presently aware of any changes to the UCMJ. So the UCMJ remains the same, which will be subject to other webinars and other presentations. You may find YouTube videos discussing those. That's not the scope of today's presentation. I welcome your questions. In fact, I have a list of several questions from those who have already signed up, and I plan to answer as many of those as possible. Some require individualized attention and private discussion, so I can't answer those in a public forum without breaking confidentiality. So if you have a question that concerns your specific particular situation, it may be best to set up a consultation on our website or calling our main number, 518-218-7100, to discuss your particular facts without breaching privilege and confidentiality in a public forum. This is open to the public. Anyone in the world, whether you're in Nigeria or Nebraska, can listen in. So we want to keep it a high-level overview of our discussion. Let's move into the next slide, please. Okay, one of the first things that Secretary of Defense, Pete Hegseth, the former Fox and Friends host, now Secretary of Defense, former Army captain, and he may have gotten promoted beyond that, but he was Special Forces soldier. He's the new Secretary of Defense. So first thing he did, in accordance with the administration's policies of President Trump and an issue that they ran their campaign on, was okay, well, yeah, was the elimination of what's been known as DEI or DEIA. What is DEI? Well, it's kind of an amorphous description standing for the acronym Diversity, Equity, and Inclusion. It primarily came about from diversity initiatives, but then after 2020, there was a large-scale nationwide cultural awakening to injustice and a large number of corporations to show that they cared compassionately about those who were inflicted with injustice started rolling out what they called DEI initiatives. You know, the NFL is a great example of that. They started promoting different advocacy organizations and saying that they really care about social justice and they want to give back to the community and they want to promote money and funds to different organizations. And then corporations started saying, oh, yeah, we care about those who are downtrodden and suffering, and we hire those who are afflicted. So we value diversity, equity, and inclusion. And, you know, for a long time, for at least a couple of decades, mostly everybody understands the concept of diversity. You know, it's good to have a diverse team. You want to have multiple talents. You want to have those who are, you know, young and those old, and those who are, you know, versed in certain areas and those who are versed in other areas. It's good to have a mixture, because the more talent you have, the more cross sections you can you know, just like a food court at the mall, right? You want to offer multiple options to make everyone happy. So diversity, the intent behind diversity was to try to please as many people as possible, just like a food court would. You have Italian, you have Chinese, you have Chick-fil-A, you have all these different options. Hopefully everybody can eat something. At least in my family's point of view, that works out great because everybody likes something different and we all get to be happy eating something different. So that's the whole thing about diversity. The concept of equity and inclusion spans that, and from the administration's perspective, the inclusion of the words equity and inclusion trampled on the intent behind equality under the law, because equity is not necessarily equality. Equity is trying to find fairness, and fairness is open to interpretation. So I don't want to opine politically on what all this means. Some of you, well, very well may be super excited about these executive orders and think these are the great development and a wonderful policy change. And others, understandably, are horrified and literally suffering physiological medical conditions associated with, you know, pain and agony over the changes. Don't want to cause either celebratory response or just you know, harm. I just want to provide what the information is, and you can take it for what it is. As a neutral umpire, as an attorney, just like a judge, my job is to call balls and strikes, not to say whether the pitch was good or bad, or whether it was you know, the wise decision or unwise decision. It just is what it is, either a ball or a strike. You may think the curveball is in the mud and terrible, or you may think the fastball down the middle is awesome. And I'm not here to discuss the merits of the policy changes regarding suitability, whether they're great or good or horrible. I'm here to just tell you what they happen to be. So let's move in to what the content discusses. What's happened is the offices associated with DEI have been abolished, meaning those individuals whose job was to promote diversity, equity, inclusion have been placed on administrative leave, and the promotion of certain initiatives, the DEI, has been rescinded. For example, the Secretary of Defense canceled all celebrations of Black History Month, all celebrations of Women's History Month, and all months associated with those sorts of celebrations. So as you move through the calendar, there's Pride Month, there's Hispanic Heritage Month, there's Women's History Month, there's Black History Month. All of those have been abolished from an official capacity. So there's no longer official, with the Department of Defense at least, no longer official recognition of these celebratory holidays that previously had been promoted by the Department of Defense. Other initiatives being removed are, you know, different elements saying we want to focus on diverse recruiting. For example, the Air Force ROTC selection said there were too many white male pilots, so we wanted to really try to get non-white males to be pilots in our ROTC recruiting. That initiative has been canceled. They're no longer going to take into consideration eligibility for pilot selection based on race, gender, or any other immutable characteristic. It's going to be entirely based on credentials, aptitude, meaning do you pass the test, do you pass the physical requirements, are you capable, medically, are you capable intellectually, are you capable physically, and if so, you meet the criteria, you're passed. We're not going to try to encourage one group or another over another group. So the intent, at least, by the elimination of these DEI initiatives, is to stop what the administration sees as a previous focus on hyper categorization, hyper focus, such as with the Air Force pilot situation. If you go on a plane, statistically speaking, it's likely the pilot's a white male. That's just statistics. Whether that's good or bad is not really my opinion. I'm not here to opine on that one way or the other. It just happens to be a statistical fact that most pilots are white males. There are obviously pilots of all races and categories, but statistically speaking, the Air Force over the last, history of its existence has generally had most pilots be one group. So the Air Force was trying to have more female pilots, more pilots of racial minorities. Well, that initiative is now canceled. However, anybody who's capable is still eligible to take the role. So don't think of this policy change as somehow now authorizing affirmative discrimination. The intent is non-discrimination, at least as according to the language of the policy, meaning nobody should be given advantage. Everybody should be at an equal footing. The purpose of equity, obviously, was not everybody starts life off in the same spot. So the idea was to give somebody who may have started off poor a leg up. Well, that's been removed. So now you're going to have, if you start off poor, you're going to have to really struggle and work harder than you did if you weren't. I sympathize. I started off relatively modest life background and worked my way through different hurdles, but I certainly share the upbringing concerns of those who don't start from a more socially economic advantage background. Secretary of Defense policy here, across the board, a lot of changes, but the recruiting emphasis on diversity conferences, all that's been canceled. So there was a large gig out there of recruiters going to quote unquote diversity conferences and living out of hotels, promoting different initiatives. All that's been canceled. That is the removal of eligibility for individuals who identify as transgender to serve. So this is a policy that reverts back to a prior policy. President Biden was the first presidential administration, Obama in his second term was the first administration to open access to members to join the military who identify as trans. President Trump canceled that policy. Then President Biden became president and he reinstated that policy. And now Trump is president again, and we're back to the initial policy we had prior in Obama's first term, which was you're not eligible. So a lot of whiplash there, but go to 2012, individuals who identified as trans were not eligible. Go to 2016, they were eligible. 2018, they weren't. 2022, they were. Now 2025, they're not. What that means is there's a lot of writing back and forth on the eligibility for assessment into the military. The military, according to the courts, is authorized to determine selection criteria for those individuals who wish to join. So you have to be a certain body fat percentage. Under the American, below a certain body fat percentage. If you're morbidly obese, you're likely to be denied entry into the military. That runs counter to the Americans with Disabilities Act. But the American Disabilities Act doesn't apply to the military. So a large number of statutory protections that are anti-discrimination provisions of the law simply are inapplicable to the military. For example, Title VII doesn't apply to military selection. So generally, the courts have said it's national security. So the military can decide who joins, and the military, under the purview of the executive branch and the commander-in-chief, gets to decide the selection criteria. That's how for the first 200 years of our military's existence, those who identified openly as homosexual were prohibited from the military. If you read AR 600-20 or other regulations prior to 1992, it said words, and I'm just reading it directly from the regulation. It said homosexuality is not compatible with military service. That was the language in the regulation. that language was changed under President Clinton to a don't ask, don't tell policy. Then it was changed further to allow open service by those who identify as homosexual or bisexual or to serve openly. And there's no change to that policy. That policy remains. There's not been a reinstatement of don't ask, don't tell. There's not been a reinstatement of prohibiting those who identify as homosexual to serve. And I don't anticipate that would change. However, there's this additional category of transgender, those individuals who maybe identify as a non-binary or other gender descriptions beyond male and female, or transitioning from one, biologically born male, but transitioning to female, or born female, transitioning to male. That is no longer going to make someone eligible to sign up. If they identify as non-binary or non-gender specific, they're not going to be eligible to serve. Those who've already signed contracts who are currently serving, that's going to be subject to a different webinar we're going to hold in March, because once you have signed an agreement and once you're serving, you have certain statutory rights to continue serving. However, eligibility is the easiest access point to cut off, because for new people trying to join, if you identify as transgender and you openly provide that information to the recruiting department, they're going to tell you you're no longer eligible to join per Executive Order 1404 and other and the Executive Order dated January 27, 2025. So eligibility has been cut off. Now they can do that legally because the military, under the direction of the Commander-in-Chief, gets to set whatever criteria for selection they so choose, and the courts will not interfere. The courts will say there's a national security exception to all the legislative anti-discrimination provisions. So absent something that's constitutional violation when it comes to parameters such as ability to run a certain speed, having a certain height, weight, other characteristics, the military is allowed to affirmatively discriminate and limit selection criteria. I know it surprises a lot of people, but the military can be selective on who it takes, and 75% of those who try to join the military are denied for one reason or another, whether they have a criminal background issue, a drug use history issue, a medical issue, whatever it might be. Transgender is now, according to the policy, considered a medical condition that is ineligible for waiver. No different than asthma. Asthma makes you ineligible for military service absent some kind of waiver or therapeutic intervention. So if you identify as transgender and you do wish to serve, my legal advice would be to identify as the biological sex of birth and not openly admit your transgender identity. Then you would be able to serve. You would just have to do so no different than those who served who were homosexual 60 years ago by just not disclosing that identification. That's how you get around that. All right, let's move on to the next slide here. The reinstatement of service members discharged under COVID. Now this is a big one. Why? Because the military kicked out 8,000, 9,000 people that we know of who refused vaccination. Although individuals were authorized to request an exclusion or exemption or waiver of mandatory vaccination, 99.9% of those requests were denied, arguably in violation of the Religious Freedom Restoration Act and other laws that would have allowed either a medical exemption or other sorts of exemptions for vaccination. So individuals were removed from the military, and now those individuals are eligible for reinstatement. What that means is, and I'll go into this here in a second. Sorry, I had to drink some water. If you kicked out 2 years ago and you were 87 and you're a civilian now, but you still want to join, you still want to serve, you have to just come back in and you'll get 2 years of pay. So this is a nice windfall for those individuals who got out, got on a job, and were working. You're going to be put back in the position you were in had you never left and reassigned probably according to the needs of the military. So if you are one of these 8,000 people, I would encourage you to contact the Department of Defense and find out where you go to get your orders published to collect your back pay and go back to active service. If you need help with that, we are here to assist you for that process. Now, again, if you were kicked out for height weight problem or insubordination, for disrespecting your leadership or drunk driving and vaccination refusal, then you're not eligible for reinstatement. You have to have been removed for the sole basis being vaccination refusal. So somebody who happened to beat their spouse up, get thrown out, and also refuse the vaccine, they're still not going to be eligible because the misconduct associated with the assault is going to make them ineligible for reinstatement, even though they may have also been a vaccine refuser. So don't get that confused. You have to have been kicked out specifically for refusal of the vaccine and not be the only basis of why you were removed from the military. And if so, then you're eligible for reinstatement. And again, like I said, there's 9,000 people in this situation. Some may have passed away by now. Some may have moved on with their life and not want to serve. But those that wish to serve and go back to the military career are eligible for reinstatement and full back pay. And that's going to take probably some congressional appropriations to fully fund, but that's something you should try and collect. You're talking about potentially hundreds of thousands of dollars if you were a military officer and you've been out, kicked out 2 years ago. Okay, let's move on to the next slide here. Removal of abortion travel authorization reimbursement. Okay, there is a law in the that's been around for 40 years now called the Hyde Amendment. And the Hyde Amendment basically says no taxpayer money should go to facilitating payment for abortion. That's federal law. It's been that way for 40 years. Whether you are pro-abortion or anti-abortion, I'm not here to opine on the merits or lack of merits to this policy. The law happens to be the Hyde Amendment prohibits funding. The Biden administration cleverly got around this prohibition, arguably in violation of the Hyde Amendment, in violation of law. So there was a lot of litigation about this issue, and the litigation now is moot because the administration has changed the policy, meaning litigation by individuals who thought it was an inappropriate, unlawful use of taxpayer funds to fund individuals for abortions. What was happening was, if you're assigned to Texas, say at Fort Cavazos or Fort Bliss or any major installation here in Texas, in the state of Texas, abortion since 2022 is illegal, meaning it's totally unlawful. There's no exceptions either. So if you get pregnant and you wish to have an abortion and you're in Texas, you have to either go to Mexico or go to New Mexico or some other state where it's lawful to have the procedure. And if you're in the military and you're assigned to the installation, you're generally required to be at work. So if you need to perform, need to do this, you would need to get leave and travel. The Department of Defense under President Biden said, okay, if it needs to happen, we'll reimburse you for the costs associated with traveling to New York and the hotel and the airfare and everything else. Now that reimbursement is canceled. So if you wish to have an abortion after being pregnant in Texas, you have to pay out of pocket at your own expense for the costs associated with that medical intervention. That's the current memorandum. So basically, recoupment of funds for abortion is no longer authorized. However, they did keep recoupment of funds for reproductive assistance for IVF. So individuals who travel for procreation purposes to try to have children may still be eligible for reimbursement. Those who are traveling for pregnancy termination, the eligibility for reimbursement of funds has been rescinded. So that policy, in accordance with the Hyde Amendment, is now back in effect. So that's the law on that. I'll answer questions regarding that if you have some, but bottom line is those who received recoupment, that's vested, that's done, it's water under the bridge. You want to pay it back, but going forward, you're not going to be eligible for compensation if you incur travel-related expenses for that care. You're going to have to get that worked out logistically with your unit and command, separate and distinct from any kind of reimbursement from a DoD level policy. That's changes to installation names, other policy pronouncements. Okay, so as everyone may have heard, Fort Bragg is now Fort Bragg again, meaning it was Fort Bragg for a long time, like 100 years, And then, according to the National Defense Authorization Act, all Confederate names had to be removed. So it was renamed Fort Liberty. Well, the Secretary of Defense decided to rename Fort Liberty after PFC Ronald Bragg, a airborne soldier in World War II who won Medal of Honor or some other distinguished characteristics. So, in accordance with the campaign promise from the Trump administration, they are in the process of renaming installations. I don't know if they're going to find somebody with the last name Hood who has valor to rename Fort Cavazos back to Fort Hood, but I anticipate that happening at some time. They'll probably find somebody named Bill Hood, and he was a captain somewhere, and he did something, and they're going to say, now we're renaming Fort Cavazos back to Fort Hood, but we're not naming it after General John Bell Hood, the Confederate general. We're naming it after Mr. Hood, who was a great person. That's probably coming. Anticipate that over the next few weeks. As of now, the only installation that's been renamed back to its former name is Fort Bragg. And that was something that was a promise by the current president on the campaign. So may have missed that, but that's happening. So we'll see how that plays itself out. But names of bases, names of mountains, names of geographic locations are all changing. Mount McKinley has been named back to Mount McKinley from its new name under the Obama administration of Mount Delaney. The Gulf of Mexico is now legally in America, the Gulf of America. So it's going to take some getting used to because I live in Houston in the Gulf of Mexico area. But legally speaking, under the federal statute now, it's the Gulf of America. In Mexico, still calls it Gulf of Mexico. So Google Maps has it Gulf of Mexico in Mexico, and it has a Gulf of America in America. Go figure. Anyway, that's renaming installations and bases and places is an ongoing thing that's going to be happening. So I anticipate the new names that you may have started getting used to will be reverted back to the old names as we progress. I didn't learn all the new names, so it might be easy to remember the old names and just keep it that way, but that's going to be happening. Now, the Iron Dome, I want to talk about that. There's going to be more missile defense spending anticipated to protect the country. Israel has what's called the Iron Dome. So when Hamas and Hezbollah shoot rockets into their country, the Iron Dome fires in and blows them up. Ukraine has an Iron Dome to some extent. When Russia fires missiles and rockets into their country, their version of the Iron Dome has shot down quite a few of those incoming missiles and protected the Ukrainian population. President Trump, under the executive order for the Iron Dome, is going to set up similar capacity here in America to try to prevent incoming missiles for America. We'll see where that goes, but I anticipate that involving more defense spending. The other policy we're going to talk about here is clarifying military role in protecting the territorial integrity. This goes to the border emergency declaration on the first day of the new administration. The president has made a decision to mobilize active military forces to guard the United States southern border. That is something legally the president's authorized to do. It's the territorial integrity of the country should be respected and protected, and that's completely legal. And I anticipate further spending along the military border to stop unlawful entry and unlawful contraband entering the country. That's basically the policy there. Not too many questions about that. That was something that was a big campaign promise of the new administration, and implementing that and having a military role in that. Now, there is a question legally to what extent active members of the military can enforce civil federal immigration law. That's to be determined. There is legislative authority under the Alien Sedition Act and the Insurrection Act to use domestic law enforcement purposes for the military. Those are rare exceptions that are rarely invoked, and generally under the Posse Comitatus Act, law enforcement is supposed to be done by civilians, not members of the military. However, the exception is the Insurrection Act, which President Eisenhower invoked in 1956 to order members of the military, the active military, to integrate public schools in Arkansas. President Bush used the Insurrection Act to end the LA riots in 1992. So there has been historical use of military for domestic law enforcement purposes under the Insurrection Act. Eisenhower is a great example. By forcing the integration of schools, he actually sent the 82nd Airborne to Arkansas to walk students into classrooms to make sure that their rights to attend were protected pursuant to the Supreme Court decision. So that's going to be an area where you may see military confusion and policy debates about what extent the military can assist law enforcement with enforcement of immigration law. And that's all developing. So I intend to see a lot of litigation associated with that and probably further issues associated with that. But if you're in the military, you have to keep in mind all your orders are presumed lawful. So if you're ordered to go arrest migrants who are in the country unlawfully, that could be a lawful order if it's done pursuant to the Insurrection Act or the Alien Decision Act. Again, could be. I haven't seen an order like that, so I'm speculating. And it also could be unlawful if it violates provisions of the Posse-Comitatus Act and there's no applicable exceptions. So be very careful. If you're in the military, you may be ordered to do things you personally disagree with, and the way out of military service at that point would be to petition for conscientious objector status, and be released from active service because you no longer can morally perform the duty, but you have to have a legitimate, good faith, conscientious objection. Otherwise, you're required to perform your orders, whether you personally think it's a good idea or not. That's outside your purview as a member of the military. So let's move on to the next slide. I want to talk about one development I've noticed is there was a pent-up demand for, it appears, or those who did not want to join under the prior administration seem to be signing contracts. The Army had its best recruiting month in the last 15 years in December, likely in response to President Trump being reelected president. The President Biden implemented a lot of policies that many individuals found repulsive, such as the DEI initiatives, the focus on diversity and equity and inclusion and gender anti-discrimination provisions and other stuff like that. So people who are politically conservative may have been deciding, you know what, I'm not going to join the military. It's not for me. And now that the military has switched gears and changed those policies, those from a more traditional conservative background seem to be signing up in the military. I don't know if that's going to continue or if that was a one-time, pent-up demand, but we'll see. The military changing its focus to going back to war fighting versus social justice causes may well increase the recruiting pool. I mean, my own personal experience in the military is the people in San Francisco who are anti-war hippies generally were not your recruits who joined the military. People who joined the military were generally moderate to conservative, and many were very conservative who were patriotic from rural areas. And if they weren't from rural areas, they were from impoverished backgrounds of our major cities and doing it for love of country, but also to gain a status change in life and to use the benefits to help themselves out. All valid reasons to join the military. I think you'll see an uptick in people from rural communities who may have decided not to join the military over the last 4 years now joining. So I can anticipate our rural area stationed recruiters will have an easier time signing people up to join the military. You have counties in this country where literally 90% voted for President Trump. They're small counties. They're not geographically large population-wise, but you have large swaths of the map where it's considered quote-unquote Trump country. And those places, many people were not joining the military, and now it seems like they're going to just go back to their predisposition to be volunteering for military service. You have high schools in this country where half the class would join the military, and you have other high schools where nobody would join. There is a lot of variance depending on geographic region of the country when it comes to intent to join the military. The military is heavily from the South, and the military is heavily from lower socioeconomic backgrounds. I grew up in Dutchess County, New York. In my high school, I had 2,000 students, and only 2 people joined the Army. And I was one of those 2. And in West Texas, you have high schools with 100 kids, and literally 50 joined the military. So that's the variance within our own country on the differences between who joins the military and who doesn't. And that's something to take into consideration when it comes to dealing with members of the armed forces. Now, there's plenty of people in the military who are super progressive. but there's probably many more who aren't. So just keep that in mind as you consider military service. Let's move on to the next slide, slide 12. All right. One last thing I want to touch on was there's a massive backlog of security clearance adjudications. What is all that? You might be wondering, I never heard that term before. A security clearance adjudication is you fill out a document called an SF-85 or SF-86, and the government runs your background. And they run your background to see if you're eligible for access to sensitive information. That is something required if you join the military as an officer. It's also required if you work for a federal employer as a contractor and you need to have access to sensitive information. You may be required to get a clearance. If you have a clearance, it was taking a long time for these to get approved. The intent now is to bypass some of the protocols and get more approved faster and hopefully break the logjam of vetting. But there is a concern that some people may be approved without thorough background checks. So we'll have to see how that plays out. If you have a security clearance question or concern, that's one of my main practice areas. So I practice 3, maybe 4 areas of the law daily. One is military criminal defense, military administrative work. 2 is federal employment work, USERA, and state employment work. 3 is security clearances, and 4 is ROTC, Service Academy, representation for cadets and students facing expulsion from those programs. So that's my 4 areas. The clearance area is ripe for concern. A lot of changes there that are going to be happening. We'll have to see how the criteria changes regarding eligibility. But as of right now, the guidelines associated with eligibility remain the same, and the backlog that existed from the prior administration. But the intent is to have that worked through and get more clearances approved. But we'll see. We'll see how things go as far as what happens there. So we can move on to the next slide, summary here. I'll try to sum up everything we talked about today and leave some time here for questioning. First, it's been a privilege to speak to all of you. Thank you for attending this afternoon's presentation. Vitally important to talk with counsel. And I want to use this opportunity to remind everyone, I know it wasn't really the scope of this seminar, if you ever get called for questioning by the police, the FBI, NCIS, CID, OSI, you name it, don't talk to them under any condition. Even if you have a foolproof alibi, talk to counsel first before you give any information to investigators. Their job is to get you to make admissions against interest and to basically prosecute you and ensure those who do want to prosecute you have evidence that's against you that's adverse and set you up and ruin your life. So don't talk. And if you do, you're asking for a world of hurt. So don't do it. Additionally, as you may have seen from the news, if you're paying attention to daily news developments, executive orders seem to be being published every single day. Quite literally. I think every day they break into the White House with the president at the Oval Office, talking to the press, signing more orders. So I don't know if that flurry of activity is going to stop anytime soon. So what does that mean? That means the president is actively expanding the scope of executive orders daily and testing the limits of presidential power and presidential immunity and presidential authority. We'll see what the courts do in response. But in the meantime, as the orders are published, they are directing federal agents, federal officers, federal employees to do certain things. And insubordination, noncompliance is grounds for termination and removal. So even though some of the changes in policy may not be welcomed by individuals who are required to execute them, if they're lawful and published according to law, then generally they're valid, even if you don't like them. So there are some limitations to that, and we'll see what the courts do regarding pushback against that. There's been a lot of litigation. Some courts are saying yes, some courts are saying no. Things will eventually go to the appellate courts, and then they'll probably split, and then they'll eventually go to the Supreme Court. So I anticipate the summer, next fall, Supreme Court being very active, resolving questions of dispute regarding what the executive branch can and can't do when it comes to the publication of these executive orders. But what I can tell you is the president's constitutionally strongest when it comes to operations within the military. The courts are very loath to interfere in military operations or second guess what the military is doing. And who ultimately is in charge of the military? That's the president. That's the executive branch. So if the executive branch says, this is our new military policy, you can bet the courts are going to say, okay, that's the president's decision. The only check on that is the voters and maybe Congress if it's too extreme, but the courts, we're not going to get involved. That's a political question outside our purview. If it's something blatantly unlawful, the only remedy would be congressional impeachment and congressional removal. And that's highly unlikely unless it's, something we haven't seen so far. So that being said, if you're a member of the armed forces, remember your oath as an enlisted member, your oath is to obey the orders of the president. If you're an officer, your oath is to abide by the Constitution. If an officer disagrees with an order being provided, they can object, but objections, the burden is on you to prove the invalidity of the order. So remember that when it comes to disobedience. And if it's a lawful order and you don't like it and you're not complying with it, you face removal and sanction and career termination. So be mindful of all of that too. It could be problematic for individuals who are required to follow orders they personally don't agree with, but that's their duty under their oath they signed for their agreement with the military. So keep all that in mind as you move forward. And at this time, I'm going to try to answer some of the questions individuals may have, because I think we've covered all the main topics of the webinar. Let's see if there's any new questions. I'm going to go into some questions that were already previously sent to me. All right, let's see. How is the EO cases impacted? The new, EEO cases should not be impacted one way or the other, and I'll explain why. There's a lot of disinformation concerning DEI and SHARP, DEI, and EO. EO has not been changed. Equal opportunity is the law. Equal protection under the law is still the statute. DEI arguably was trying to put the hand on the scale to benefit one group over another. That is no longer permissible. That's no longer authorized. However, the EO claims are still going to need to be adjudicated. So there shouldn't be any change to those dispositions. Is it possible removal of certain individuals to adjudicate those claims may tip the scales? Yes, absolutely. You've seen people fired from the NLRB, from the EEOC, from different federal agencies, people voluntarily resign. So you can imagine those being replaced might be less inclined to process claims. But the idea that SHARP has been removed, SHARP is a sexual assault prevention program, that's not going to change. Okay, sexual assault is going to remain criminalized and prosecuted to the fullest extent. So sexual harassment is now a criminal offense under the UCMJ. Again, one of the first things I said is none of the content of the UCMJ has changed. So some misinformation out there is, oh, now that we got rid of DEI, we can go back to being, boys can be boys and we can just sexually harass all we want. No, you can't. Absolutely not. That's not anything to do with anything. DEI, again, may have been eliminated, but treating everybody with dignity and respect is still required. Okay, so keep that first and foremost in mind. And if you feel aggrieved, you still have all the legitimate mechanisms in place to file complaints through the EO process, the military, through the IG process, and all the anti-discrimination provisions of the regulations are still in existence. Okay, it's just the idea, at least as published, was to give everybody equal playing here. Nobody gets like 5 extra points or something if you happen to be one group or another. That's the intent behind the DEI elimination. But it doesn't mean you can go out and discriminate. It does not mean you can now decide, oh, we're going to favor white guys. That's not lawful at all. That would still be subject to an EO complaint that would be legitimate and have to be investigated and adjudicated. What can federal contractors do to prepare? Well, I think that's another question I've got. And I think if you're a contractor and your company has certain DEI policies, you might want to look at those again and see if they need to be rescinded or modified to some extent. Again, a lot of gray here. And the boundaries of this gray is to be litigated. So some companies like Target have gone out of their way to, try to not emphasize DEI as much. Like, for example, Target had a Pride Month display that in certain, locations like Texas, people were throwing a big fit about. So in Texas, at least, they got rid of all of it. In California, they kept it all. I noticed that because I traveled between the both states, and I walked into Target in Texas, and all the Pride Month stuff was gone. But in California, it was right there at the front of the store. So it's going to depend on location and local market to some extent. But if you're in Texas and your company's here, it's probably prudent not to be openly promoting DEI if you're a contractor. If you're in California, you might be able to get away with it because the California, policy and the public policy of California is obviously quite different than the public policy of Texas and the general community disposition. Impact on Board of Corrections cases. I don't anticipate there being any impact other than it may take longer for decisions to be published because according to information I've received, the news, 80,000 people, approximately 75, 80,000 have signed up for the quote buyout, where they're going to be on indefinite leave for a long period of time. How many of those work for the Board of Corrections? I have no idea, but I can anticipate cases that were already backlogged, already taking way too long for a decision, taking even longer now because some individuals may have decided, you know what, this is not where I want to work anymore. I'm going to take the buyout, buy another job, move on with my life, and now you're going to have less manpower, fewer people doing these jobs. So it might take cases longer to get decided. So I would anticipate the backlog getting worse before it gets better. Again, to fix that, call Congress and tell them the Board of Corrections is a scam, add more resources to it, and take it seriously because frankly, truthfully, it's a joke. It's a joke because Congress doesn't want the letters coming to them. They want you to go to the Board of Corrections. The Board of Corrections, 95% of the time, does not do a thorough review, tells you no most of the time, and doesn't actually look at the stuff you actually submit. So it's kind of a disingenuous scam. It's not legitimate. It should be legitimized by actual review of the material by being fully staffed and fully funded and having competent individuals actually do the work. And that's really hit or miss. Having a lawyer involved can increase the odds, but only so much. And only if we actually get somebody to review it who actually cares about doing a job correctly. Sometimes it happens, sometimes it doesn't. So Board of Corrections cases, I could have a whole webinar on why that needs to be reformed. And that's a whole different topic for a different day. Disability ratings, medical evaluations. I don't anticipate any changes to that, except for the fact that, again, as we talked about already, those who identify openly as transgender are no longer medically eligible to join the military. If you are currently serving, you have legal rights to continue to serve, and you have to be thrown out through legitimate processes that may or may not be followed correctly. So you may be able to push back and keep your career going, or you may have to have an alternate disposition. We can talk about that, and we're going to discuss that in the March webinar more thoroughly. Let's go on. Another question here. Telework. Telework has been canceled, to my understanding, for a large number of employees. That's being litigated because I believe individuals signed agreements with the union to permit telework for a long period of time. And I don't know the authority of the cancellation, if that's going to be upheld or not. So I would, as a cautionary tale, if you're currently teleworking and you want to continue to telework, it's best to consult with counsel to see if you have some kind of claim under the Americans with Disabilities Act or other legitimate authorization for exceptions to the policy. Because the policy change now is telework has been canceled, you need to report back to the office. Well, if you live in Kansas and you're getting DC locality pay because you're supposed to work in DC and your office is in DC and you want to keep working for the government, you may have to relocate back to DC, or you may decide taking the buyouts in your best interest because you want to stay in Kansas. There's a lot of situations like that. And if your situation calls for a resolution, I invite you to reach out to us and we can try to figure out what's the best course of action in your situation. But a large number of people who are teleworking live in like Nebraska, but their office is in Los Angeles. Obviously, that commute's not going to be doable on a daily basis. So you may have to figure out your long-term plan there. In the meantime, getting to the office is been ordered, so you may have to comply, at least temporarily. Schedule F, that has not been implemented to my extent. It's coming down the pipeline. What that means is individuals to be employed who are then subject to removal on an easier basis without MSPB protections. That's outside the scope of this webinar, but I will say I can anticipate the administration hiring individuals and putting them under a schedule, or at least trying to at least, it gives them less employment protections and makes it easier for them to be removed. That's going to be happening, and I think that's going to be something the administration focuses on over the next several years. So if you do work for the government and you take a new job, you may not ever get permanent status where your job is relatively protected. You may be in an indefinite probationary status where you could be terminated at will. That's something to take into consideration because many government jobs don't pay a lot. So you may or may not want to actually change your life based on that. EEOC cases put on hold pending administrative updates. I'm not aware of that. I did hear that some of the Department of Labor Veterans Employment Training Service work has been temporarily suspended while individual employees are on administrative leave. So again, the EEOC process takes a very long time. It's very hard to get an appointment. It's very hard to get a claim started. If you need help with the EEOC claim, we're here to help you out with that. So call us and we'll get it set up for you. That's really outside the scope of this webinar, but again, the law on EEOC has not changed. Title VII has not changed. The law saying you can't discriminate based on age, race, gender, sexual orientation, all that still exists. These policies are designed to tip the scale in one direction, but they haven't changed underlying statutory mechanism prohibiting discrimination. So if you are facing discrimination because you're Hispanic or because you're Moroccan or whatever national origin, you still have a valid way of redress, but the process itself might be slowed by the current administration's situation. Veterans with disabilities and telework. Again, if you are a veteran with disability and you need a medical accommodation pursuant to the Americans with Disabilities Act, you may be eligible for an ADA type accommodation to permit telework. That's all to be determined on your individual facts. But a general blanket authorization to work from home, that's been canceled. Whether you get an exception to that cancellation will depend on your specific facts. So if you have a medical condition pursuant to the ADA because you're a VA disabled veteran, you might be given permission to work remotely. But again, it'll be on your individual specific facts. And you may be denied. And if you're denied, you may be left with a tough choice there, whether you quit or not, and whether you fight back or not. And we can help you out with that on an individual basis. How can federal employees protect themselves? Well, if you are a federal employee who's probationary, your protections may be minimal. If you have gone beyond probationary status and you're working for a long period of time, you generally have legal rights and MSPB protections. And I would advise you to consult with either your union representative or counsel if you have individualized concerns. That's beyond the scope of this discussion, and I can imagine individuals having concerns. We're here to help you out one through another. Next question I've got here is, can the president rig the DOD? Well, the answer to that, short answer is yes. That the president is ultimately the commander-in-chief. So the president's decisions, as long as they're not unconstitutional, are not unlawful, are valid. So if the president orders the military to commit war crimes, that would be an unlawful order. But if the president orders the military to invade Greenland, that may be a lawful order. It may be completely ridiculous, but it might be lawful. That's to be determined. And it could be plausible. I mean, President Clinton bombed Yugoslavia. President Bush bombed Iraq. President Obama bombed Afghanistan. President Biden bombed Syria. Using military force with or without congressional authorization is generally authorized. Pursuant to the War Powers Act, the president doesn't have to give notice to Congress until 90 days after the operation's already begun. So just about every president has used the military for their leisure and their personal policy preferences to the extent maximally permitted under the Constitution. Again, President Clinton did so in Yugoslavia and did not have congressional authorization. I think congressional authorization was defeated, but ultimately the mission ended relatively quickly and the issue legally died from a moot perspective. So the answer to that question is, again, go back to my warning from the very beginning. The courts, and I hate to be crass, but they just don't care what the military does. Because if they did, they would stop a lot of the lawful stuff we bring to their attention. They're often deferential to the military to such an extreme degree because they don't want to get involved in the internal operations of the armed forces. So they'll just let the military do what they feel they need to do. And the military has to abide by the orders of the president. So it's generally considered lawful. It has to be really extreme for the courts to get involved and for relief to be granted. It does happen on occasion, but it's quite rare. And it's exceedingly rare because, again, the courts are excessively, in my opinion, excessively deferential to the military. Telework and unions, again, that's going to be on a case-by-case basis. Now, if your job was, I got one last question I'm going to answer here before we wrap this up. The question is, if you were hired to work remotely, can you keep working remotely? My answer to that is, the answer is probably, but again, I don't know, because they may or may not be able to change that, and you may or may not have eligibility for continued status in the remote capacity, or you may have to report to the office. And again, you have a right to say, you know what, I don't want to do that, I'm going to quit. You absolutely have a right to leave employment if you find conditions unbearable. Remember, there's no such thing anymore under the Constitution of indentured servitude. So if you're working for the military, you basically sign a contract allowing that kind of status in exchange for compensation. And you have to follow the orders. But again, if you're a civilian and you don't want to work with, don't want to comply with the government's new directives, you can push back legally potentially, or you can resign and move on with your life. Those are your options, and some of those may not be desirable, understandably so. I can understand a large number of people may have anxiety or concern regarding ongoing developments. Stay tuned. There's more things in the process, more things in the pipeline. And I also understand that many people are probably excited about these changes. So again, my job as an attorney is not to editorialize excessively. My job is to try to just tell you what the law happens to be and give you the advice, and then you make the decision on what course of action you wish to take, having full knowledge of the law. And don't listen to what we call military barracks attorneys, okay? A lot of barracks lawyers out there on social media telling other soldiers that, EO's canceled and Sharp is gone and it's free game to do whatever you want. And that's all a bunch of horse manure, okay? I can't use any stronger language in a public forum, but I would use profanity if it was permissible to say that is absolutely incorrect. Don't listen to it. Don't listen to barracks lawyers. Listen to qualified, capable counsel that's credentialed, that's legitimate, and take advice from such accordingly, okay? Well, I hope everyone has a good afternoon. That pretty much concludes our presentation. You can contact me at stimmons@tullylegal.com. You can also call our number at 832-241-5888. It may be difficult to get a hold of me. For example, my last 30 days, I started off in Richmond, Virginia, litigating and settling a case with my colleagues and partners. And then I was out in San Diego, and then I was in Germany, then I was in Portugal, and I just got back from Fort Bragg. So that was just the last 30 days. Just about every 30-day period of time is a similar situation where I'm in North Carolina, then I'm in California, then I'm in New York, then I'm in Florida, then I'm in Oregon, then I'm in Italy or wherever it happens to be. Again, members of the military are stationed everywhere around the globe. We have multiple attorneys capable of assisting, and I appreciate being in high demand, but I'm going to try to spread the love around for the travel in the future to more people so I can stay home and raise my family. But we'll see. I've said that every single year for the last 9 years, and I've been on the road every year for 100 days a year, every year for 9 years straight, and probably going to keep doing that for another 20. So it's great to enjoy the world and see different places and different things. And I appreciate everyone being involved today. And if you have further questions, feel free to email me or set up an appointment to have a discussion. And again, I apologize for the lack of depth for this discussion. It wasn't designed to go into the weeds on any of these particular orders. It was to give a generic overview of what's going on, so you have an understanding of some of the biggest changes. And if you have specific questions, feel free to reach out. Thank you.